So now we move on to our next subject matter, which is contracts. And obviously, contracts are going to be a significant part of practicing real estate. You got to understand contracts. You're going to be writing up contracts. But let me say a couple things right up front before we even get into the meat of this stuff. But I said you're going to be writing contracts, and yes, you are, and no, you aren't. Excuse me. These contracts are already pre-printed. Okay. Now there are different versions, different types of contracts. We're going to be talking about a lot of different types of contracts, but not every real estate company or office uses the same contract. For example, a contract of sale is going to be required to to sell real estate, to buy and sell. But there are different versions of the contract of sale, and different companies, offices will be using different contracts. So not every contract of sale will be worded the exact same. We'll get into some more of this a little bit deeper into this module. But what I wanted you to understand for right now is these contracts are already pre-printed, okay? So it's not like you're actually writing a contract of sale. So, but when we do refer to you need to write up a contract of sale, we're talking about just filling in blanks, okay? That's all you should be doing with these contracts. You're just filling in blanks. Now, I'll just tell you, if you get to doing much more than filling in blanks, you better be careful. I'm just going to leave it at that for right now. I will tell you, if you're actually writing contracts and maybe even adding other provisions, you're adding a bunch of stuff to it, that could be considered practicing law. Okay, so to write a contract, that has to be done by an attorney. And the last thing you want to be accused of is practicing law, and you're not an attorney licensed to do that. But it's been determined that if you're just filling in blanks, then you're okay. You're not really writing the contract. You're just filling in blanks. But where you could get in trouble is when you start adding a bunch of stuff, or in some cases even deleting stuff from the pre-printed contract. You don't want to do that. Okay. So just wanted to throw that out there right up front. So let's take a look at some terms, definitions that we're going to be talking about a good bit. Actually, what you're looking at here on this slide, these are some of the topics that we're going to be dealing with or talking about as we go through this module. And now I'll just tell you, obviously because contracts is this is a significant part of real estate. And if you don't fill out the contract properly, you can cause a lot of legal issues, financial issues for clients. And I'm telling you, if you create a financial problem for a client, they may very well turn around and cause you a financial problem before it's over with. So you've got to understand contracts, and because of that, they're going to put a fair amount of emphasis on the state exam about contract. Meaning, you could expect quite a few questions out of this module. You got to understand contracts. So, I'm not going to sit here and read through all these topics here. You can see them. They're also in your material as well. But again, let's start out with some terms that you're going to need to be familiar with as we go through. The first thing we look at is the term called expressed. You can express contracts in one of two ways. Obviously, one would be orally or in writing. You could do it either way. However, There are certain types of contracts that are required, must be in writing if it's going to be enforceable. But then there are other contracts that are not required to be in writing, to be enforceable. And I'll just tell you, the key here is something called the statute of frauds. Okay. The statute of frauds is a federal national law that I'm not going to get into a lot of detail right now. You're going to see it later. But basically what the statute of frauds indicates or requires, any type of contract that would be subject to the statute of frauds, it must be in writing if you expect it to be enforceable in court. I will just go ahead and take, just for example, contracts of sale, they are subject to the statute of frauds, which means contracts of sale must be in writing. They cannot be agreed to orally. There are other types of contracts that may be required to be in writing, by state law or state statute, and that will vary by state. So, depending on what state you're in right now, we'll talk about some of those requirements when we get into the state-specific part of the course. But right now, the main thing I just want you to know, statute of frauds requires, or any type of contract that is subject to this statute, it must be in writing. And contracts of sale, I'll just go ahead and tell you, they are subject to the statute of frauds. Okay. But then, speaking of these oral contracts, or sometimes you even might hear it referred to as implied contracts. Obviously, these are not in writing. But these are contracts that have been established just by the actions of the parties, okay? And certain implied contracts are enforceable, as long as it's not something subject to the statute of frauds. But, for example, if somebody comes to cut my grass or asks me to cut my grass, we agree to how much how much I'd have to pay him. So he cuts my grass and I pay him. He comes back next week. He cuts my grass again and I pay him. Comes back a week later, cuts my grass and I pay him. There's nothing in writing, but at this point, the person cutting my grass, doesn't he have the right to assume if he cuts my grass the following week, he should get paid? Yes. Because of the actions that have taken place up to that point, clearly indicate we have an implied agreement. I cut, you pay, right? That's the agreement, even though nothing's in writing. And I will tell you, all they would have to be able to prove, if the person just decided, I'm not paying. I didn't specifically tell you to come this week, so I'm not paying you for this week. They could take you to court and they would win, right? Because they could prove there was an implied contract here. And I will tell you, cutting grass is not something that's subject to the statute of frauds. So that would clearly be enforceable. But some of these contracts that are implied, not in writing, they can be and are, some of them, enforceable. So by the time we get finished with this module, hopefully we'll be able to understand which types of contracts must be in writing to be enforceable and which ones are not required to be in writing to be enforceable. We got to understand that, and we're going to talk about it. You see this next term, bilateral contracts. Obviously, how many is bi? 2. So if you have a bilateral contract, that means you have 2 parties that are agreeing to do or maybe not do something. For example, in real estate, the buyer promises to pay, the seller promises, let me back up. The buyer promises to buy the property, the seller promises to sell the property, when they sign this contract. That makes it a bilateral contract because you now have 2 parties agreeing to do something. But you could have, in some cases, a unilateral contract. Well, obviously, how many is uni? One. So if you have a unilateral contract, that just means there's only one party that's actually bound to the contract. The other party would not be. So a bilateral contract means both parties, two parties, are bound to the contract. Unilateral means there's only one party that's bound to the contract. And I will tell you, these are most common in your option to buy. I'm not going to get into the details on what an option to buy is right now. We will be getting into much detail a little bit later on in this module. But just to let you know, an option to buy would be an example of a unilateral contract. Okay. Then we've got executed and or executory contracts. Now, this is where you got to start paying attention and be careful here. Because, there's a few terms here that, like executed, executory, they're very similar. Excuse me, but there are some differences, and you got to be careful that you don't choose the wrong one here. If you have an executed contract, that means all parties have fulfilled their obligations. Goodness. There's nothing else to be done. In other words, we've closed. Once we've closed, that means buyer's done everything they agreed to, seller did everything they agreed to. The contract is now fully executed. But let's say you have a house under contract, but we have not closed yet. There's still things the buyer's trying to do, maybe still things the seller's trying to do. We have not closed yet. So obviously the contract has not been fully executed, but it is in a executory state. So, that just means we have an executory contract. Sometimes you might hear the term ratified. You have a ratified contract. Ratified just means both parties have agreed to the terms on what each party will do. It's just we haven't completed all those terms yet. They haven't all been fulfilled yet. So that's considered executory contract. All right. But here's probably the one. I'm sorry. But here's the one that's probably where most people get confused. The difference between a void contract and a voidable contract. Void just means, obviously it says here, there's no legal effect or consequence. So if the contract is void, then there is no legal effect. It's as if there was never a contract even agreed to. It never even existed. So obviously once a contract is void, there's absolutely nothing enforceable or have any legal effect whatsoever. It's just void. But voidable is a little bit different. Voidable just means you have a contract that could be voided by one of the parties. Again, doesn't mean it is void. It just means it could be voided. Well, how would this happen? Well, let's say you got a buyer makes an offer on a house. Say they offer $200,000 for the house. And the seller receives the offer. They look at it and says, nope, I can't sell for $200,000. That's just too low. So he says, I'll go to $230,000. I'm just throwing out numbers. So the seller decides to make a counter offer back to the buyer. Basically saying, I'll go $230,000. Well, when you make a counter offer, either party for that matter, whether it be the buyer or the seller, but whoever makes a counter offer, that renders the entire contract voidable. Because when that buyer receives that counter offer from the seller, the buyer has a decision to make here. and and it'll have to be one of three decisions. They could just accept the counter and say, "Fine, I'll pay $230," or they could counter the counter and say, "Well, no, I can't go $230, but I'll do $220." So he just countered the counter. Or the third option is, "Forget it, I'm out of here." In other words, they could just terminate or void the contract. Okay. So if that buyer decides to just say no to the counter and walk away, then that voids the contract. But while the buyer is trying to decide what they want to do, which one of these three options they're going to go with, the contract is considered voidable. Again, it's not void until the buyer decides, "I'm out of here," and then it becomes void. But again, while they're still considering it, it's considered voidable. So the main thing I would say, just make sure you understand, and certainly for real world purposes, and make sure your clients understand this. If your client decides to counter an offer or even counter a counter, which happens all the time, and they may need to counter, but just make sure they understand what they're doing when they make that counter offer. When you make a counter offer, you're putting or rendering the entire contract voidable. So for example, if that seller wants to counter the buyer's offer, I would typically tell the seller, "If you want to counter it, that's fine, and I'll be glad to do that. Just want to make sure you understand before we do it. There's a chance the buyer could say no and just walk away. And if they walk away, then the deal's it's over. You cannot continue on." Because I've actually had sellers tell me, "Well, if they say no, then I would agree to just accept the original offer. I just want to see if we can get them to go up a little bit higher in the price." Well, you can't do that, okay? Because if they say no, if they just walk away, then the contract becomes void. And what did we just say earlier? Void means. It means there is no contract. It's as if it never even existed. So, playing these games, your clients just need to understand the legal ramifications, to what I consider playing games. Because a lot of times you'll have a seller that get an offer which would probably be acceptable. They like it. They just want to see, let me just see if I can squeeze a little bit more out of that buyer. Let's just counter back for a little bit more and see if they'll do it. And you can do that, but just understand you can't go backwards. If that buyer says no and they decide to walk away, then it's over. So my question to you, seller, is this: before we counter, are you okay if the buyer decides to walk away and we have to deal and just look for another buyer? Now, if you're okay with that, make the counter. But if you're not okay with that, if this is an acceptable offer, then I might recommend you consider accepting it rather than just playing these games by trying to get them to go a little higher. Hopefully that makes sense. Kind of got long-winded there, but it's very important to make sure you understand the difference between void and voidable. And when you make a counter offer, that renders the contract voidable by one of the parties. And which one is it? The one that received the counter. They can void the contract at that point and walk away without penalty. Excuse me. Then you got enforceable and unenforceable contracts. And hopefully this one's not too difficult. Enforceable contracts just means that, one, it includes all the terms and conditions, all the valid or all the requirements to create a valid contract. And we're going to be going over that next on what those valid requirements are to make it enforceable. But y'all remember some contracts, certainly the contract of sale, y'all, that is required to be in writing to be enforceable because it's subject to the statute of frauds. In fact, I'll just go ahead and tell you, pretty much any real estate contract, any type of real estate contract is going to be required to be in writing. Just go ahead and get that off your mind now. Anything dealing with real estate is more than likely going to be required to be in writing. Now, there is one exception to what I just said. There is one type of real estate contract that can be oral and still be enforceable in court. And that would be an oral lease for 1 year or less. As long as that lease does not exceed a year, then it's still enforceable, even though it was never put in writing. Y'all, because we have the implied has in effect here. Y'all, the tenant's been paying X amount of rent, landlord's accepting it, it's now an implied contract. Y'all, that is enforceable in court as long as it does not go beyond a year. Y'all, if it goes beyond a year, then it's no longer enforceable in court. But y'all, unenforceable contracts are those that do not have all the legal elements, y'all, the essential elements of a valid contract. I will tell you there are 4 essential elements. If any of those are missing or lacking in the contract, then that would render the contract unenforceable. But y'all, there are essential elements that must be included, must be agreed to in order for the contract to be enforceable. Y'all, we'll talk about in more detail what those 4 elements are here next. Okay. Y'all, the valid or invalid contracts, y'all, valid just means it does contain all the essential elements of a contract. Y'all, those 4 essential elements, again, coming up next. As long as all 4 are present, have been agreed upon, then it's considered a valid contract. If you have a valid contract, that means it's also enforceable in court. But if any of these essential elements are missing or lacking, then the contract is considered to be invalid, meaning it's also unenforceable in court. So you got to have a valid contract for it to be enforceable. Invalid contracts are not enforceable. Doesn't mean you can't do it. Doesn't mean the parties cannot still do what they agreed to. It just means it's not enforceable. So, y'all, again, we'll talk more about that coming up. And then the last of the terms, y'all, definitions is reformation. Y'all, contract reformation. Y'all, occasionally you could have conflicting statements within the contract. Y'all, especially if you start writing stuff in. Y'all, you see it quite a bit, quite frankly, where an agent might have wrote something into the contract that parties, would agree to. But maybe whatever they wrote into the contract completely contradicts or conflicts with something else that's already pre-printed in the contract. So you got one statement that printed here that says one thing, and then you wrote something else into the contract that totally contradicts what was pre-printed. So now you got an issue. So which one do you go with? Because you got 2 conflicting provisions within the contract. Which one do you go with? Y'all, that's where reformation would come into play. And when it comes to reformation, it says anything that is handwritten will carry more weight than something pre-printed. So again, if you had one provision that was pre-printed in the contract and then something that was handwritten into the contract that conflicts with that, then obviously based on reformation, that means we're going to go with whatever it was handwritten. Because anything handwritten carries more weight than something that was already pre-printed. Yeah, I don't know that this is that big a deal really in real estate, but it could be. But Reformation also suggests that letters carry more weight than numbers. So if there's a contradiction there, an example I'll just give real quick there. If you're writing a check, for having, I don't know how many people still write checks today. I do, but if you write a check and say you're writing a check for $100, well, you have to write the the numbers, $100 over to the right, but then right below it, in the line below it, then you have to spell out $100. Well, what if I wrote or put $100, where the numbers are, lost my train of thought, and for some reason I wrote $10 on the line below. So you got a contradiction here. In one spot on that check it says the check's for $100, and then the other spot it says $10. Well, how much is the check good for? $10. Again, because Reformation, when you have contradictory statements, and by the way, a check is a contractual agreement. That's a contract, by the way. Then the check's good for $10 again because letters carry more weight than numbers. So I would just remember, anything handwritten carries more weight than something pre-printed. Letters carry more weight than numbers. Okay? So those are your terms and definitions for contracts.